evade arrest for 4 days.
Do we have an affidavit to that effect from the arresting officer?
Your Honor, we have sworn that it is a factor that has to be considered by the court. Your Honor, in the interest of time, and I ask this with tremendous humility because I have been interrupted so many times in my life. You give us just a few minutes so that my colleagues could highlight one or two issues that we had intended to highlight and which we had allocated. So we just take a few minutes, Your Honor. Very few minutes. We understand the kind of pressure you have on time. So then, Mr. Ombachi will answer.
You have a total of 5 minutes, the two of you.
I'll take a short period, then I'll leave to my senior.
So 5 minutes.
5 minutes for me, 5 minutes for Mr.
For both of you. I'll write first.
You write first?
Yes.
So, my Lord, I associate myself with the submissions of my senior,
Your Honor.
Mr. Perry. I must add that on the question of whether the accused person is likely to attend court proceedings, I wish to rely on the case of Kelly Bunjika versus Republic and be availing a copy to the court.
The case of
Kelly Bunjika versus the Republic, a 2017 case. The trial for the charges facing him. The court in this case also raised that there must be compelling reasons that must be demonstrated that the accused person is likely to fail to attend court proceedings. The question in this matter becomes whether, on the nature of such defense and evidence is not disclosed, the accused merely asserts his constitutional right to be granted bond and bail on reasonable and favorable terms. I'll ask you to, you'll be able to look at the case where the accused person was denied bail. In this instance, the accused person in this case has at all material times to these proceedings taken the form of untouchability and invisibility. He has openly and freely posted on something that he has never qualified to be. And when caught, went into hiding, updating his social media, almost with no fear that he stood the risk of being apprehended. The accused has been flanked and supported by his politically influential godfathers, who seemed...
Madam Obiango,
Yes?
are you submitting or testifying?
I'm submitting. Tongue in cheek.
Okay.
And he has declared, as you have seen in the video that has been presented, that he will only surrender to law enforcement at a time of his convenience and choosing. And Your Honor, you've been able to watch the scene. The attitude and conduct described herein paints the picture of an entitled offender who believes that the criminal justice system should wait for him and not that he should be answerable to it. And in the circumstances he neglected his duty to conform to the criminal justice process and it's our argument that when it appears that he may be apprehensive of the outcome of the proceedings, there is a likelihood that he will abscond trial.
And trial of an accused person. And the duty to protect, Your Honor, and underline this, the integrity of the criminal by interfering with witnesses or intimidating them. There is a need that may arise for the court to deny bail or bond. And the other consideration, Your Honor, is that in the interest of justice, to demand for the protection of the public.
Please don't repeat what has been said by someone else.
Stands here as a victim, also wears another hat. It wears the hat of a regulator of the profession. And under section 4 of the Act, 4B, one of the statutory functions of the society, of the law society, one of the statutory functions of the society, of the law society, is to protect and assist members of the public generally. That is a statutory function. Generally, that is a statutory function, and that is one of the hats that the society wears in these proceedings. And Your Honor, based on that, the society therefore presents 5 compelling reasons to this court why the accused person should not be released on bail or bond. Number 1 is an affront to the justice system. Your Honor, it's an insult on our collective intelligence. Your Honor, one of the duties of an advocate under Section 55 of the Advocates Act is to be an officer of the court, meaning that you have a duty to the court at first as an advocate and then to your client. Your Honor, the accused person has been preferred charges of masquerading. And Your Honor, that poses a grave threat to the administration of justice. As a second, in fact, even my grandmother laughs at me now. Your Honor, the 4th reason is that producing a fake certificate as one of the charges that have been of employment, Your Honor. It poses a fatal risk to the public. and oftentimes leads to grave injustice. Such a relief. The same danger is posed by those that are not qualified to practice law or who masquerade. That is the fourth compelling reason that this society presents to deny the accused person has been in courts in this country. The sixth reason, Your Honor, is that they are genuine members of the public out there, and we've seen this even on social media. So the accused person has won 26 cases. 26 cases, meaning he has 26 different clients out there who believed that he was an advocate. And Your Honor, that poses a grave danger to the public. And Your Honor, if you were to release him, the seventh reason, Your Honor, is that the accused has no gainful employment or fixed place of abode.
You said you are down in 5.
Yes, Your Honor, I'm finishing in another 1.5. No gainful employment or fixed place of abode. Your Honor, in terms of character and antecedents, Your Honor, the accused, Your Honor, not only as he injured us as members of the legal profession, he wants to use his story to lionize himself, to tell his story as a sort of a Robin Hood of this profession. Your Honor, what that means is that you are court, as the court that ensures that the integrity of this profession and the criminal justice system is maintained, must look at that antecedent. Your Honor, in the alternative, if you were to grant him bail, we pray that you grant him bond terms and no cash bail. Your Honor, impose a gag on him. Impose a gag on commentary in the social media, because, Your Honor, it's causing further damage to the legal profession in an irreparable manner. Your Honor, and this gag should also go to his political godfathers. And those who want to associate with the story or narrative, as he puts it. And, Your Honor, he should present himself to the police for investigation or plea taking whenever is required and not at his convenience.
We took plea yesterday.
Yes. In case of new charges. Because the prosecution has said that there was an ongoing investigation about other matters. Your Honor, it's important that this matter is matter that is for this court and not on the social media, and therefore the accused person, his godfathers, and those that want to sponsor him should not comment about this case and try to lionize him out of his criminal antecedents. Thank you, Your Honor, for the time that you gave us.
And I've discovered that I have misadvised the court on the issue of the law during my submissions regarding to the standard that should be taken. Your Honor, I indicated that 2 others against the Republic reported in the year 2017 of electronic Kenya law report, which confirm and rule that the standard is the balance of Mayadi advice court.
You'll go first.
Yes, I'll go first, the senior will go. Now, pursuant to your advice, I take a preacher's view. I will take the tone and a religious view. One, Your Honor, that do unto others what you expect to be done to you. Point argument is one. The DCI has refused, neglected, or rejected to do an affidavit. The DPP cannot swear that affidavit. That tells you a lot. The DCI is the only constitutional body allowed to investigate. Nowhere is LSK given that mandate. No affidavit by the DCI to show the accused never appeared before them. No affidavit from the DCI to show his flight reason. Actually, the Law Society of Kenya, its membership, its membership, where I belong, completely feels ashamed of the council. Number 2, Your Honor, you have been told this is a public interest matter. Former governor and others are presenting the accused as an advocate. You know, when you look at social media,
Pardon? Former governor and others?
they have told you of public interest that the accused is showing himself to the public and extorting them as an advocate. The photos I've given, just
Mr. Mari.
Yes, Your
Send some release
Fine,
orders.
fine. The release order is okay.
Sorry for that. Told my, we were to have a meeting, so all my colleagues have gone. I'm the only one remaining.
Thank you. We understand the job of the head of station.
And there are people who have paid fines. Can't keep them.
Your Honor, kind permission, as you have 2 minutes, as you have decided that, be escorted.
It's okay. It's okay.
Thank you.
This one I can't read. Yes. I can't read. Yes, Mr. Omari.
Yes,
Uh,
Your Honor, I said I'll be very, very brief.
yes, Mr.
Yes, Your Honor, it is the counsel.
You're sorry, Your Honor, to interject. I don't know, the court has not made aware on whether or not it's proper for us to consider to proceed without the accused person, although the application has been made.
Don't delay time.
It's an important question of law. Very important. It's very important because it may reshape these proceedings. Then maybe as we wait for the accused, we'll also give notice that will go.
Yes, Mr.
Can I proceed?
Yes, please.
Your Honor, the accused does not intend to produce the documents as exhibit.
May I say something?
Your Honor, I'm on my feet.
May I say something, Your Honor?
Allow me to speak so that.
No, I think you better sit down. Honor, we would like to make an order for this young man to be released on bail immediately so that he is free. I am of the old order. The dignity of the bar is clearly what it should be. What it should be. I'd like to be very respectful without saying very much. order the release of this young man forthwith in the place of what is necessary. Without any conditions. I now have information. If you want us to resume, we can resume later on. Again, I appeal to you. For the sake of good order, it is called to in the country. The order is released immediately. And you give us a date when you can affect it. And you want to, may I say with respect, take what I've said to you.
I stop there to save the Law Society of Kenya.
Yeah.
Let's proceed.
The one if I may
That's all.
tell you, as one who has been a member of the Law Society, the Law Society of Kenya spearheaded this secondary reparation in the country.
He's writing my ruling.
Hmm?
He's doing my ruling.
No, I don't want to my ruling. I want to just release it. Your Honor, I'm not asking Your Honor to make a ruling. All I'm saying to you, release this young man. What time is it now? What time is it? What time is it?
It's 5. Let him write a ruling to release him. He must write.
No.
He can't release verbally.
Don't write that. Your Honor, the second liberation in this country was made by the Law Society of Kenya. At the time I'm just in the court, people are skipping some of them. People like Kitogi Manyara, people like Yamala. Above all, let us also save the dignity of this court. You will not write a ruling, just make an order. Coming on walk back. Right. We adjourn the matter and you give us another day. We have to preserve the institutions we have under our constitution. Again, I appeal to you that if he is a young man, and it's not a threat to a court or else, when I also come to talk, things will go back.
So, Dr. Kamino, when do you want to come back?
Your Honor, I always obey you. If you tell me when you want me to come, I will drop whatever I have. I always obey what you say. And you know, I have appeared before you many times. Many times. I always obey you. If you tell me, Kamino, come tomorrow, come next week, come in December, when you have probably relaxed during the holy month, I was doing, but I always obey. So if you tell me, I'm going to come to it. I'll go to my diary. But Your Honor, I plead with you, let me walk out of this day.
Does it happen that?
You can make an order.
Okay.
So the place is water coming out. Your Honor, we have to maintain the dignity of the court. You have to maintain the dignity of the bar. Uhuru Kenyatta said words that are not forgotten. One is in power temporarily, not in power forever. Our present president of the Law Society is in power temporarily, in power, but we have to say the Law Society.
Given the circumstances, we'll be asking for the court's directions whether the defense have adjourned their submissions and will.
With respect to Mr. Witness,
Yes,
I look at this country in a very broad manner.
Yes.
Yeah, that's why my father and my mother took me to school.
You understand, we'll be asking for directions.
I'm more concerned about the welfare of this country more than yourself.
Yes.
Sorry, Miss Doctor.
Yeah. Your Honor, please adjourn the case. Let me walk out of this young man.
As I stated at the beginning.
You're seeing a photograph.
Sorry, Mr. Amino, Dr. Amino, sorry. As I indicated at the beginning, my intention was to hear everyone today and be able to render a ruling before the break. But now I have no option. How long will you take to finish?
What did you want?
Let's talk of Monday.
What?
On Monday.
What did you?
And we'll give you, will you take more than 1 hour? Will you take more than 1 hour?
1 hour.
So that by 10:15 we should.
You want to go put virtual hearing? Can you give us about 11 o'clock?
From 11.
What time?
Sorry, as we are consulting, Mr. Theuri, is Monday okay?
Your Honor, on Monday we have the legal awareness week, which will be launching at the parking up here. So the morning part of it for Monday is not convenient for myself.
I'm available in the afternoon, Your Honor.
Afternoon?
Afternoon we will squeeze ourselves.
Afternoon at what time?
2:30 p.m.
2:30. Madam Dorcas, is that okay?
But we have a hearing at 2 p.m. on Monday.
We have a hearing at 2.
Yes.
How about noon? How about noon, Mr. Theuri?
Pardon?
How about noon? Considering that you have closed your submissions. So after Dr. Aminwa will be having reply from the prosecution counsel. I'm saying that because at 2 we have another long hearing. So if we put this one at 2, it will mess up everything, considering the way it is going.
Your Honor, I would have no hesitation to try and squeeze ourselves. But just in case we are unable to make it at noon, then that presents a problem again. We do not wish to be put in a position where it looks like our intention is to frustrate the conclusion of this matter. So at 2:30 I would have been more comfortable because by then I'll be sure we have completed the festivities and it is extremely important exercise. So if Monday is not available, I don't know whether Tuesday is available to the court.
Let's take Monday. I'll give you the same time at 2. I'll reorganize myself.
I will be at 12 o'clock on Monday at 21st.
We are talking of 2, not 12. 2 p.m. 2 p.m.
2 p.m. It's all right, I think. I'm agreeing on all this on assumption that I will walk out to the young man.
It is now past 5 p.m. The counsel for the accused has indicated that he needs time to finish his submissions on another date. So the defense counsel to conclude their submissions on 23rd of October 2023 at 2 p.m. Since it is not appropriate to make an order for release of the accused person as sought by the defense counsel before determining the issue of whether or not to grant bail, the accused will be remanded in custody. So that marks the end of the session. Thank you so much. We'll continue.
Your Honor,
Just a clarification.
Your Honor, may I say something?
Sorry. I think we are done.